My name's Hazel Courtney. I'm president of the International Federation of Airworthiness, which exists to bring together issues affecting airworthiness and be an advocate for that profession in various forums. And we started doing these clinics, we call them, in order to give people direct access to some of the world's best experts on some hot topics. And I'm delighted to welcome today Domenico Marino, a longtime friend and colleague of mine. Dom is an international lawyer. He has taken a particular interest in issues surrounding safety in aviation, particularly some of the data confidentiality issues, but he's got a very long history in aviation. He was our international lawyer at the Civil Aviation Authority in the UK. And we're delighted to have you with us, Dom.
Great to be here. Thanks so much for the invite, Hazel, and happy to be your guest. I'm going to go out on a ledge just from the beginning and say that I think the underlying reason that we're all here today is because we all care about safety. Am I right in thinking that?
I think so. I think so, yeah.
Good. Okay, excellent. Perfect. Me too. So that's why I'm here. Hazel and I worked together for a long time, and we both share the same passion to make sure that safety is done well. A little about me. I won't be too long about me, but I'm Italian and American both. I have both nationalities. I live in Italy, and I grew up in the States and Canada mostly. I started as a lawyer about 20 years ago. It'll be 20 years next year. I know I look a little bit younger than I actually am, but I give that credit to my mother's genetics. So anyways, I started as a lawyer 20 years ago as an aviation litigator. I worked in insurance defense mostly. So I saw the consequences of bad safety management firsthand. And I spent about 5 or 6 years doing that. And then I just decided that money's not the best way to deal with safety in the sense of compensating people after a loss. There's better ways to deal with it. And it's a better use of my time to make sure that safety is done well before there's an accident. So I got into regulation and I moved to London. I joined the UK Civil Aviation Authority. Worked in both the policy and legal departments, but with a focus on safety and safety management. And it was a very exciting time for us at the UK CAA in the sense that Annex 19 was new, and Hazel and I worked together on the implementation of that. And Annex 19 was a really, really brilliant invention that we'll talk about during our session today. At the same time, the UK was part of the single market for Europe, and we were noticing that safety oversight, even though we had a common market, didn't have the same standards, and in practice was very different in different parts of Europe. So we had some concerns, and we wanted to make sure that, especially with increasing numbers of passengers flying on foreign carriers, that we could still achieve some sort of common level of safety assurance. So we worked together on a lot of projects, Hazel and I did. We both left the CA around the same time and both became independent consultants, and we've worked together since on some really interesting and key projects, but all about safety management, state safety programs. I've given a lot of advice to national aviation authorities, regional aviation associations. I'm sure you probably all heard of IASA and ICAO, done some key work with them. And, but yeah, so this is what I do, is basically give advice, give analysis of legal issues, help make sure that all countries that we can help have good safety assurance procedures at the state level and at the entity level. So it's a little bit about me.
Thank you, Dom.
Yeah.
So we invited people to send in questions ahead of time. And so we've grouped them under general headings. And I'd like to just start off with, first of all, the theme of the ICAO standards and recommended practices as compared with the law, local laws, jurisdiction enforcement, that kind of thing. So the first question, I guess, for an international lawyer is the law on this similar in all countries? Doesn't each country have its own laws and legal system? How do you approach that?
Okay, yeah. First of all, I love the questions that we've got today. I want to say that right out of the starting gate. I love the questions, and this one is very good. The answer is actually yes, the law is similar everywhere, but it's different because it's not exactly the same. And the reason for that is the standards that all countries have agreed at the ICAO level to implement are the same. However, each country does have its own legal system and different requirements. And because of that, yes, there are going to be differences in how the law is implemented. And I'm going to go a little bit into detail, hopefully without boring you guys too much about it. But I think it's important to pick up on the reason why this is the case. Towards the end of the Second World War, a lot of countries got together and had what was called the Chicago Convention about regulating civil aviation after the war. And all of the states that agreed to do this agreed to set up an international regulatory body that was going to be tasked with agreeing common standards and recommended practices. And that's today known as ICAO. It's based in Montreal, Canada. And what happens there is all the countries of the world that are represented, all the member states, get together and discuss what should be standardized as aviation regulation around the world, with every country that's a member to have the obligation to implement. So that's what happens at ICAO. It's all contained in the ICAO annexes, what the standards and recommended practices are. Each annex of ICAO focuses on a different issue. There's one on security, there's one on environment, there's flight ops, there's rules of the air, there's licensing, you name it. And then the most recent one, which is the one very close to my heart, is Annex 19 on safety management. So that's how ICAO was set up, to make sure we have some commonality. However, as you say, as the question points out, each country does have its own legal system. So there are going to be state particularities in how the annexes get implemented. So because of that, ICAO audits every country every few years and makes sure that there's good implementation of the standards and recommended practices in each jurisdiction. That way, what's happening on the ground in each country is going to be similar enough that we can say, yeah, we have safety in all these different countries and safety assurance at the national level.
So can you say a little bit more about the relationship between the standards and recommendations, the standard recommended practices and the laws? Because of course, when we transpose ICAO SOPs, that standard recommended practices, into our own jurisdictions, we generally put them in our regulations. And that's a little bit different from public law, no?
Well, there's two levels of law in the sense of aviation regulation. You have primary legislation, you have secondary legislation, which is usually what we refer to as regulation. Now, the first one is usually going to happen in most countries as an act of parliament. In the UK, for example, you have the civil aviation law. In most countries, you have a civil aviation law, which in essence gives the regulators certain legal powers within the legal system and the legal procedural system, where you make sure, and I've put a lot of these together, by the way. That's how I have a lot of experience with what you need to have in primary legislation to make sure the regulator has teeth and can actually make the companies do what they're supposed to do. You have to have enforcement powers. You have to have empowerment at the state level for the regulator, and specifically what ICAO functions the regulator is going to perform. And then in each country, it might not always be in the regulator's hands. For example, certain functions are done by the Ministry of Transport, if there is one. Certain functions, accident investigation is actually supposed to be done independently of the regulator, because often they have to issue recommendations to the regulator. So there's a conflict of interest. So it's at the state level that the ICAO membership exists. The regulator is empowered by a regulation that's done at the state, by a law that's done at the state level. And then usually what happens is secondary legislation, regulations themselves, can be changed a little bit more easily than a law, which is why usually the regulator has discretion to change them a little more easily to make sure that we're always compliant with the latest developments at ICAO and also the latest developments on the ground.
Okay. So are there any copyright issues when we all know some countries will, when they're developing some regulation or guidance material, will look at what another country's done and kind of use it as a template and maybe rebadge it. Is there any copyright issue about that?
Let me go to what I've written about that, because that's actually a very interesting question. I did a whole analysis on that because it happens frequently. I'm firstly going to say that straight away. I'm going to say it happens frequently that countries copy other countries. And the interesting thing is that ICAO actually, I'm not going to say they encourage it to happen, but I'm going to say they don't have a problem with it. And in most cases, what we call the fair dealing provisions of copyright law would allow for that, even if it is copyrighted. But in most cases, you're not going to have that. Safety is really not something that is a for-profit motive in terms of something that a court would see as needing to be protected. In actuality, sharing safety practices and being able to use best practices is something that I don't think you're ever going to see a court say shouldn't happen. So if somebody's doing it well, by all means, you're encouraged to look at what's good and what's appropriate. Finding what's fit for purpose sometimes that really is the exam question when it comes to developing regulations. What may be appropriate in one jurisdiction is not going to be fit for purpose for another. We go through this struggle all the time. For example, with the EASA regulations, sometimes you might get complaints that they're a little too particular for certain operations. And it could just be geographically, it doesn't make as much sense in one legal system as it does in another. But at the same time, you don't have a copyright issue when it comes to regulation. I'll say that pretty confidently. ICAO encourages it when it's appropriate. There's, in many parts of the world, we kind of look at it as, does this country follow the FAA in the US or do they follow EASA? Those are kind of the two leaders. There's also New Zealand is a very popular approach now too, because it's a bit simple in how it's presented. Very transparent, very straightforward. So it's very common, and I think it's actually a good thing that if you have something that works in one country very well and would work well in your country, that you can borrow it. ICAO just says you have to make it clear that this is in your regulations, what it's copied from and what it's borrowing.
Okay, so if you want to draw some inspiration from another country, it's probably not going to get you into trouble as long as you reference where you got it from and you make sure it's suitable for your purpose.
Exactly. Exactly. And the other thing about copyright is a domestic issue. It's always going to be national law that applies to copyright. Yeah, there's some conventions that apply where countries have agreed to take enforcement action based on breaches of each other's copyright law. But again, I really just don't think this is the kind of thing where if you have one NAA saying, I developed this regulation and now this NAA is using the regulation in violation of a copyright issue, I think it'd be a pretty easy defense to say the regulations are based on ICAO, first of all. They're compliant with ICAO, which is not something that is copyrighted. It's something that we've all contributed to. And second of all, the purpose of the regulations is not to profit, it's to have safety. And ultimately, if there's a safety practice that works, shouldn't I be entitled to use, for safety reasons, this regulation is going to save lives of people who are of all nationalities? I think most courts, I think every court, to be honest, would say, yeah, that's a permissible use of somebody else's work product.
So that sounds like a good sense approach.
Yeah, exactly.
So if we move on now to some of the more safety management related themes, safety information protection, use of data, safety culture, that kind of thing. We have a question here. It's a little bit longer, so I'm going to read it out verbatim, make sure we get it right. How can we make the move from a bureaucratic safety management system to a more holistic, considered approach? As a frontline worker, I see bureaucracy make the disconnect between procedures and documentation and the reality on the front line get worse. If we can reduce bureaucracy, we can make our skies safer, but the regulators seem to want more metrics and bureaucracy.
This is very spot on. I'm going to say that right away. It's very spot on. And it's the reason why lawyers make a lot of money and make everybody else miserable. I hate to say it like that, but that is kind of what really happens. But I do have to say something revolutionary here. Laws don't make people safe. They don't. They never have, and they never will. What makes people safe is actions. It's the actions that you take every day. It's your judgment, your use of your judgment. That's what makes people safe. Now, that being said, you know, some actions are widely known to be safer than others. And so what we want to do is encourage those actions. And in some cases, we have to standardize those actions to make sure that we have a common denominator. Because remember, what the regulator has is an obligation to say if an operation is safe or unsafe. And the only way they can do that is by having a regulation. If you meet the standards of a regulation, you get your approval. If you don't meet the standards of a regulation, you don't. So ultimately, that's the regulator's job. Now, within organizations also, there's a need to document what you do and to make sure that you can demonstrate. What compliance is about being able to demonstrate that you're safe. Now, that being said, there may be other ways to demonstrate that you're safe rather than just compliance, such as performance. And if you look at performance data, and indeed, the way that we get safer is through developing practices that in some cases are more targeted to safety. And in that process, maybe there's something that we've retained that we don't necessarily need to retain and can actually replace it with a new practice. I think that's at the heart of this question is, have we retained some things that we may not necessarily need and actually keep us from taking actions that we should be taking because those actions are going to make us safer. This is always an inherent flaw with regulation and compliance, is that sometimes by the time that you can make a rule, the rule's already obsolete. Annex 19 is actually a good solution to this, where we look at the safety management system as a whole. We look at a very holistic approach to safety management. We make sure we're not just relying on compliance. There's also within compliance itself, alternative means of compliance, which can demonstrate, well, we are taking actions to deal with this risk and demonstrate to, if you're an operator or a company, to the regulator, but also when you get audited by ICAO, to demonstrate to ICAO, we are dealing with this issue and this is what we do about it. So I would say that the system is pretty flexible on some of those things. Doesn't mean every company does it well. Doesn't mean that every company's at the cutting edge of it, but it's something we've gotten a lot better at. And Annex 19 and safety management has made us a lot better at it too, I would say.
Okay. That's good to know. You've mentioned Annex 19. One of the things that is unusual about Annex 19 maybe is that in Appendix 3, it does talk about specifically legal issues rather than things that are going to be in aviation regulation, but things that are going to go outside of the aviation system and maybe end up in civil courts. Why has ICAO seen it necessary to do that?
Okay. I'm going to take us back on a little journey back to Tenerife in 1977 when you had a major air crash on the runway at Tenerife. And that was when we first realized as an industry the importance of just culture and the importance of being able to challenge your boss when your boss is wrong. The idea of not being punished for challenging your boss. The idea of being able to also be honest about when you've made a mistake. A lot of these issues came out of the wake of Tenerife, and we've developed them since then over the years. Ultimately, where we are now is it's a body of standards and recommended practices, called safety information protection. Now, I'm one of the recognized experts in this area. Actually, I work with the Safety Information Protection Committee at ICAO on this area. What it provides for is that you are protected from punishment for anything you do that is reported or discovered, as long as it's not willful misconduct or reckless conduct or gross negligence. Now, those words, how they translate into other languages, sometimes creates some confusion, but ultimately what you do that's part of your job that you don't intentionally or recklessly do is something that you shouldn't be punished for. We should be encouraging you to talk about these things. We should be encouraging you to bring them to our attention. The only way that we get better safety is through a complete risk picture. And if we have people trying to hide stuff out of fear of punishment, that's just not going to happen. Now, because law does not happen just within the aviation regulator, it happens in courts, it happens with prosecutors, it happens with lawsuits. We have to, and usually this falls on the state, and it falls, usually the Ministry of Transport, along with the regulator, will engage in training with prosecutors and judges about how aviation data has to be used, how it has to be used only for safety improvement purposes. When you have no ability and no authority under our ICAO treaty obligations to prosecute somebody, why that is. And each state has an obligation to implement this provision of Annex 19 on safety information protection, because, and this is why we discuss this now, is because this is what underpins just culture. You're not going to have just culture without this. If a prosecutor can just get a hold of something and decide, because they're outraged about something, that they're going to bring a prosecution, there goes your just culture. There goes the idea of anybody else coming forward about making a mistake.
Sure, sure. Yeah, so just culture is really underpinned by this legislation, isn't it?
Exactly, exactly.
Okay. So who do you see as primarily responsible for safety data, confidentiality and protection, the operator or the regulator?
Both. And here's why I say both. Anybody who has access to the data is going to have an obligation to make sure they're using it as foreseen by ICAO SARPs and then local laws that transpose the ICAO SARPs. What each state has to do is develop a safety data protection policy. The regulator has to use it, they have to develop it, and then they have to make sure that the stakeholders are using it. But ultimately, as we said, the goal is going to always be only using safety data to improve safety rather than engaging in punishment. But both of them are going to have obligations. What those obligations are is going to depend a lot about what the local law prescribes. Again, this is where you have the ICAO SARPs as they're transposed into local law. One thing I just want to say as a very relevant side note is there is actually within the ICAO audit a specific look at how well the legislation implements the primary legislation implements ICAO. And if you want to know how any state is doing on that and how well they did on their most recent audit, you can find that on ICAO's website. So it is something that's not entirely transparent, but transparent enough that you know how well your state's doing.
Yeah, indeed. Yeah, that's publicly accessible information, right?
Yeah, exactly.
So again, this is a little bit of a longer one, so I'm going to read it all. If a regulator owns equity in a company that it regulates, it's the ultimate form of regulatory capture. In this situation, can a regulator ever have the public's best interest at heart and lawfully regulate?
Not at all. I'm going to say that, not at all. I know that there's some reference to what happened with a financially insolvent operator that then the regulator took some interest in. I would say that's a little bit of a different situation, but I am going to say this happens. This does happen in a much more obvious way in some parts of the world. I've seen it happen. It's not a good thing. Conflict of interest is a very serious issue. a regulator should never have stakehold in a company that it regulates. Ultimately, destroys the whole point. In law school, they taught us a football analogy: the ref can't play. If you're the one making the decisions as to what's right and wrong, you can't have your feet out on the field kicking around the football. It just doesn't work. It completely tilts the whole system. So that's an issue. Sad fact, though, is that corruption is rampant everywhere. This is a big issue that we deal with, and I've dealt with it in a lot of countries where sometimes you see somebody with a job title because they have the right last name, and sometimes they're not the best at doing their job, but the idea that you're going to get them replaced is just a non-starter. It's definitely a big challenge that we have. And the other thing is what can you do about it? Yeah, there's anti-corruption authorities in most countries, but they're usually focused on financial corruption issues. They're not really going to pay attention to this. So it's the kind of thing where a lot of us lawyers, yeah, we get bothered by it, but at the same time, we just kind of have to make sure that safety assurance happens anyway, going around these issues.
Okay.
Yeah.
I just want to check if there's any in the chat. Are there any questions on these themes before we go on? No, I don't think there are. Okay, that's good. Okay, so can we move on then to themes about culpability and the consequences and recourse that people have?
Sure.
Okay. So what are the limits of responsibility for nominated persons and accountable managers?
That's a great question. And I see two issues here. First is, I think, personal liability for company acts. That's something I think somebody who asked this would be interested about. But then accountability to a regulator for safety regulation obligations, which is a little different. The terminology used here is what we have in terms of safety management, though. This is not legal terminology that's developed by lawyers in courts. So it's different in terms of your accountability for what your organization does. You know, accountable manager usually, and the reason why that term was developed is because before we developed the term accountable manager and some of the Annex 19 provisions regarding what accountability means, it used to be that you could sit on the board, you could have corporate officers not really think much about safety. They'd have a safety team that would be in charge of safety. They'd say, yeah, just get on with safety, no problem. We found that wasn't adequate. And we said, no, at the top of the organization, you need to have safety be given a seat at the board, at the table, where key management decisions are taking safety into consideration. And yes, our auditing teams, our oversight teams are going to be asking you about as you take business decisions, how is safety factoring into them? So the title accountable manager, and it's also the same when it comes to nominated persons, when you look for who's the go-to person for each area of your business, it's about regulation. That's about regulation. But I want to talk just for a second about civil and criminal liability because it is an issue. Liability is established by national law. It's not established by ICAO, so it's going to be different in each country in terms of what liability an employee has for an action that they perform on behalf of the company. There's also different approaches to law. And I don't know if you've ever heard of the term common law, but that's a reference to the Anglo-Saxon legal tradition. And if your country was once part of the British Empire, you're likely to follow the common law system. If it's continental European, or if your country was once part of one of the empires of continental Europe, you're probably going to have a civil law system. And they're very different approaches to liability, punishment, and all these things. So it's just very important. And, you know, like case law is very prominent in the common law system. Code law is a lot more prominent in the civil law system. And then as you get to other parts of the world, there's other approaches to law. In terms of what obligations you have and what liability you can have as an officer or as even an employee of your company for what you do, it's going to be entirely dependent on your local law.
Okay, thank you. So here's an interesting one. What is the most trouble a safety manager could get into for doing the wrong thing with safety data? Can an individual engineer face legal problems because of reporting or not reporting? Has anyone been prosecuted in the past? If so, what happened?
Okay, I'm going to start with the last part first. And yes, there are mandatory occurrence reporting schemes in most jurisdictions. There's some things you just have to report. The consistency, though, about how different jurisdictions have implemented MOR schemes, we call them, and what is actually going to be included in MOR is not very consistent at all between jurisdiction and jurisdiction. I'll say that just having seen it across different countries, that this is one area where what you're required to report in one jurisdiction is very different than other jurisdictions, and also what punishments there are for not reporting is also very different. And the way enforcement's taken against somebody who doesn't report something that's in an MOR. But let's just say that ICAO safety information protection applies in this situation, as we talked about, meaning it's only to be used for safety. That also applies to voluntary reports. And according to ICAO, you should never face legal problems for reporting, and you shouldn't face any punitive or retributive action from your employer for reporting. So you should always be encouraged to report. And there also may be state level whistleblower protection laws that apply to you. It's going to be very, very regional is what I'm trying to get at. It's not very consistent. To the safety manager, I'm going to say this. The worst trouble you can get in for doing the wrong thing is going to depend on what exactly happened. It's going to be very fact specific. Was the data shared by mistake or intentionally? If it was disclosed improperly? Was it maliciously, without malice? And those are all going to be local laws that apply. Those are just some consistent themes that I've seen. I'm not aware of any criminal prosecutions for it, but that doesn't mean that they don't happen. I'm well aware of administrative and punitive action taken against licenses, fines, and also within the employment context. So that's where I would say there's more exposure for, and again, the question's a little vague for if you do the wrong thing. Well, what does the wrong thing mean? It can mean a number of things. It could mean improperly disclosing it. It could mean using it for punitive purposes. It's all going to depend on your state's regulation on that.
Right. So it sounds then like, though, a common factor might be whether it was an inadvertent mistake or whether you deliberately went out and did something.
Exactly. And I'll say that one of the issues I had after the Germanwings crash back in 2014, I believe it was that right away you had the prosecutor out there talking about what the cause of the crash was. It's not appropriate. Even though we all had an idea of what it was, there's a process that's set up for how we're supposed to investigate accidents and how we're supposed to use data. And the idea that the prosecutor's office just comes out and says, this is what happened, and this is what we're going to be looking at, I thought that was jumping the gun quite a bit. It's a frustration that we have as regulators sometimes, is even though we've trained prosecutors and judges to act a certain way, well, they don't always do that. Once you get data outside of where it's supposed to be, outside of the organizations and outside of the regulator, it can be misused. And that's the real fear, is if we see people doing that intentionally, it really bothers us. If we see articles in the Daily Mail saying that something's unsafe when it actually is the data that's making us more safe, that really bothers us.
Sure. Okay. In the event of a major fatal accident, if a company's safety processes are found to be inadequate, can a charge of corporate manslaughter be brought If so, by who, and has it ever happened?
Okay, this is a very good question. Not only has it happened, I've personally been involved in a situation where we had a real fear, some of us on the legal team, that an organization we were representing was going to be charged with corporate manslaughter. I can't give any more details on that for confidentiality reasons, but I can talk about the issue generally, certainly. I'm sure you won't be shocked when I say it all depends on the jurisdiction. It all depends on local laws because this is a criminal issue. But there are some common themes about it. In jurisdictions where this is a criminal offense, charge is always going to be brought by the prosecutor on behalf of the state. It'd be no different for an aviation company than it would be for any other sector. Corporate manslaughter would be dealt with by the prosecutor. It would really be outside the scope of anything the regulator would get involved in. And the penalties are going to be those that are provided by the local law. So what could happen? Well, that's all going to depend on what your state says is supposed to happen. There's a lot of jurisdictions, very prominent ones, that don't have a corporate manslaughter statute. And I think that's important to point out. The US is one that doesn't have any corporate manslaughter statutes. They have a reliance on civil law and very severe verdicts, very severe financial penalties as a way to keep companies honest is kind of what they rely upon. And there's a lot of countries that follow that approach. A lot of countries do have corporate manslaughter statutes, and they're pretty prescriptive about what can happen. I'm going to say this, though, as fewer and fewer accidents happen, and this is because of improvements that we have in safety over the years, you see fewer and fewer fatal accidents. The public's appetite for and tolerance for them is also going to decrease. So when they do happen, I think there's going to be a little more scrutiny on what did happen to cause them. And because of that, I would say it's just very important that we've got our I's dotted and T's crossed as we perform our safety obligations. Oh, I think you're on mute.
Yeah, I'm muted myself.
Okay.
If there was a fatal accident and it was discovered that there were people who knew about a certain situation but didn't report, even though it was reportable, what would the consequence of that be?
Let me see what I've said about this. I want to make sure I get the whole thing here. That's a very good question. Okay. Well, if something's supposed to be reported as an MOR, you likely face the consequences that apply for not reporting. So whatever an MOR is, the fact that it results in a fatal accident doesn't mean you're going to be civilly liable for causing the fatal accident, but it does mean that you're going to be, I mean, not necessarily. It does mean that you're likely to face whatever the penalties are for not having fulfilled your reporting obligation. I put as a note here, and this is why I wanted to make sure exactly what I said in my notes. Be careful with this one, though. Be very careful with this one, because your country may have criminal laws which are not specific to aviation regarding failure to prevent disasters. And I'll use my own country as an example. In Italy, we have laws which prescribe criminal sanctions for failing to prevent a catastrophic outcome. And there was a big earthquake in 2009 up in Abruzzo, in L'Aquila, and some of the engineers were jailed because they failed to predict an earthquake. And there's some parts of the world where just the idea that anybody gets killed who shouldn't get killed means somebody has to go to jail. And in those jurisdictions, there is a bit of a fear culture around am I doing my job right? Or if something were to happen, what can happen? Now, we all have different ideas. Jonathan Alec, who's the head of the Safety Information Protection Committee at ICAO, and myself, we coined a term which we call legal anthropology. And the idea is that law is always going to reflect the underpinning values of society. And if society has a very, very low tolerance for the idea that anybody gets killed who shouldn't, they will make sure there's laws that punish people, even if we don't think they should be punished, just on the idea that somebody needs to be punished because these people shouldn't be dead. It's one of the biggest hurdles we face when it comes to safety information protection is showing that more people are likely to die if we have a poor safety culture and people are not being honest about what they do, as opposed to if we put people in jail for things that they didn't intend to do, they didn't do recklessly, that's actually having a very bad effect on safety culture. Getting judges in some countries to acknowledge and understand that is very difficult, very difficult. And I've had to do it. And it takes a lot of effort using safety data to show how the positive safety culture makes a big difference in terms of our safety outcomes. You want to save lives, this is how you do it.
Yeah, I can imagine that could be difficult to someone who isn't familiar with the area, for sure.
Exactly.
So this is one about more subtle responses. If I make a safety report and don't get directly punished, but my career suffers because I've been marked out as a troublemaker, do I have any legal protection or recompense?
Well, I've been labeled as a troublemaker. I know some other people I know have been labeled as troublemakers because we're advocates for safety. Yeah, let me go to exactly what I've said about that. I've seen it happen so many times where people get punished unfairly for doing their jobs well because somebody else above them feels threatened, is really what comes down to. And it's very difficult situation. I've also been in many cases, the legal staff that a lot of people have felt comfortable coming to about their boss not listening to them. And a lot of times people know I have the ear of upper management and, okay, Dom, you care about safety. You know that I know what I'm doing. You know that I'm doing my job well, and this person's just not listening to me. So I've often been that person that a lot of people will use as a go-between with upper management to try to see if there's a way to get through to them on safety. And a lot of the so-called troublemakers would often come to me, and I would welcome it because I feel like they have something that needs to be listened to, and I have a good way of presenting it to some people who need to hear it. So I want to say this: in the legal division of pretty much every company I've worked with and dealt with, there's people who think like me. There's people who say, some of these management decisions are being made in a way that are ignoring key concerns. The key for a lot of you is going to be finding who that is. And if you find who that is, who's got the ear of upper management, that's going to help you. That's going to be a good help for you. A lot of times, us lawyers, we talk amongst ourselves about, can you believe what the board just did on that? Can you believe? So it's not something that we're oblivious to. And sometimes when the trust is shaken in your boss, you're going to want to go to somebody else. And that's going to be a key issue, I would say.
That's a good tip, because probably not everybody thinks of the legal department as somewhere they can go for this.
No, and that's the thing, is a lot of times people don't know who they can trust. And, and especially until you really know the legal person and know that they're going to be reliable to not throw you under the bus, that can be a difficult thing to do. And that's why I'm saying, be careful with it, certainly. But if you find somebody who within the legal area who's going to want to make sure this concern gets dealt with, somebody cares about safety, sometimes they have a way of presenting it to upper management in a way that upper management's going to listen. Because when it's presented as a legal issue, for some reason, the board has a little bit bigger ears than when it's presented as a safety issue. unfortunate that that's the case, but that is often the case.
Interesting.
So,
And I can imagine, that being, yeah.
yeah. And in terms of legal rights, I just want to touch on, what recourse do you have? That's all going to depend. Again, I know I sound like a broken record. It all depends on local law. Some countries have whistleblower statutes, whistleblower provisions, but I do want to say, I don't think they're very robust. I think that ultimately, if you have a company that wants to make an example of somebody, there's really not I don't think of employment law as being very robust at all in most countries. Most of the times companies get away with what they want to do. So it's very unfortunate, but that is a weakness in our system that as the aviation lawyer, it's very hard for us to have much of an impact on. But again, the battle that we're fighting is how do us as aviation lawyers who know the impact of safety and the impact of just culture on safety, how do we get the rest of the legal field on board with this? And making sure that if you don't have the right employment law, you don't have the right employment protections for whistleblowers, for people who report, there's a weakness in your system that could result in a fatal accident. Very hard to make that case, but it is one that we continuously do make.
So maybe the advice there is, before the situation arises, get to know your legal team a little bit and see if you can encourage them to make the case to upper management. Maybe.
Yeah, I would say that's the first thing to do. Second thing to do is, you have any concerns about employment law, you want to understand what your rights are. If you do go out on the ledge, talk to an employment lawyer about it, because they're going to understand specifically in your country what your rights are, what you'd be entitled to if you're dismissed unfairly or something like that. It's something that's very particular that even if I practiced in a certain country as the aviation lawyer, I would give you the same advice and say employment law is not something I can really give good advice on. All I know generally is that it's very weak in most places. So it's very unfortunate, but that is the case.
Okay. So that's the end of that
And
section.
well, one thing I should
Go ahead.
Oh, sorry.
That's all right. Go
One
ahead.
thing I would say is, a lot of times, and I probably shouldn't say this, but you know how I am. The ones I wouldn't trust are HR, to be honest. HR are there to get you on board with what the company wants you to do. That's what their role is. They're not there to tell you to keep doing your job the way you think it should be done. They're there to tell you to do your job the way upper management thinks it should be done. And if you have upper management that's not really that concerned about safety, I wouldn't go to HR. I would go to somebody on the legal team who is concerned about safety and can present it as a legal issue in terms of the company's obligations.
Okay. Interesting. Yeah. Thank you. So there was just one item left. It's not exactly phrased as a question, but perhaps you have some comments on this subject. The person submitted environment and sustainability management in the aviation sector.
Okay, yeah, and as I put in my notes here, it's not that clear what it's really directed towards. Maybe you want to know more about legal obligations for CO2 targets, CO2 reduction. The simple answer is there's not much. There's not a whole lot in terms of we talk about targets. They talk about trying to achieve stuff. There's not much in terms of obligations. Most targets that have been set have either been delayed or swept aside completely. So that's the reality, and it's true. Aviation's gotten much greener over the years. The fuel for available seat for each seat mile is a lot lower than it used to be. Aircraft have gotten greener, but there's also been a lot more flights. So many more people are traveling. So yeah, there's definitely concern about aviation's impact on the environment. And as I said, there's no enforcement powers at ICAO to make states do anything. So any targets that are set by ICAO are aspirational at best, I would say. Because even if there was an agreement at ICAO for what each state's going to do, there's nothing that ICAO can really do to force that state to do that if that state's not going to force their carriers to do it or come up with a plan for how it's going to be done. So it's aspirational at best, I would say. However, and this is the key, is this is where lawyers can be very difficult. There's the threat now that I've been made aware of class action lawsuits after disasters hit, that because of the consequences of global warming and pollution, climate change, and all this, some lawyers in some jurisdictions are saying we should hold the companies that pollute accountable for these disasters and say that they should be footing the bill for the economic result of these disasters. It's something that's already being tried. And yeah, it doesn't sound like it's that viable of a legal theory, but don't be shocked if it becomes one. Because this is sometimes how it happens, as people start to become more upset and start to allocate blame. Expect juries, especially in countries which have juries in civil law, to start making decisions that we otherwise might be shocked by. It is what I would say, and aviation is considered responsible for 2% of the emissions that contribute to climate change. So the idea behind these lawsuits is that aviation should pay 2% of the damages. You know, aviation meaning who? Meaning airlines, meaning manufacturers. But ultimately, lawyers are pretty good at trying to find deep pockets. Lawyers are pretty good at trying to figure out how to get people compensated and then put money in their own pocket from compensating them. So this is an issue I thought I would just bring up. But as social pressure increases, expect lawyers and expect environmental rights groups to get more creative as to how they're going to try to tackle it and try to force states and force industries to take more green action, so to speak.
That's interesting. So presumably then, whatever the subject is, as it gets more social pressure behind it, we could see action coming on about it.
Yeah, exactly. It's happened in so many different areas in society where once the social pressure increases, something does happen. And there's a lot of social pressure when it comes to greenhouse gas emissions. But I would say that at this point, it's not, and don't forget what they're asking states to do in order to reduce greenhouse gas emissions is basically sacrifice economic activity. And that's where states have been making up until now the decision that our economic activity takes priority over any environmental concerns that we have. Will that always be the case? Will it change? And if so, when? Those I don't really have the answer to now. But I would say that social pressure is certainly going to be a catalyst to bring this more to the forefront.
Sure.
Yeah. Okay,
interesting points. Does anyone online have any additional questions for Dom? Would anyone like to write in the chat if you do, or just
yeah, may I have one, please?
Yeah, go ahead.
Well, as an aircraft engineer and a technical person, I have been seeing in the past, let's say 15 years, maybe a lot of new regulations coming and a lot of new procedures added by the organization trying to comply with these new rules and regulations. And I think now I feel like a front line guy that sometimes basically when you talk about safety, I feel like we are compromising the real safe activity just because we want to comply with some rules and regulations. So how do you see these things? In my opinion, I think we are slightly now at the point where new rules and procedures might actually become a hazard than
Yeah, and Tom, you brought this up as well. So this is something that is, I think, important for us to look at. In the UK, we started looking at performance as a good indicator of who has good safety procedures. There was a push at the time that Hazel and I were at the UK for looking at performance, but one of the things is that to what degree can you, I'm not going to say forego compliance, but can you look at compliance? Well, let me strike that. Look at performance within the realm of compliance, because what I'm getting from both of you is that sometimes the compliance obligations don't really translate into better safety, and sometimes they actually get in the way of safety, and adding more compliance obligations isn't helping you do your job better. It's just imposing more requirements that might make it so that you don't catch something that you might otherwise have caught. Am I right in saying that?
Yeah, that's absolutely my issue as well. Is by increasing the kind of the process, you make reporting impossible. For example, you could have a duplicate inspection on everything, and if you have the same number of engineers, what would happen would be people would just sign things blind. So as a consequence, you'd end up having, you wouldn't be able to report anything, because if you found something that was wrong, you'd be like, well, I signed for that even when I didn't, and I can't say that. You kind of, by having too much process, you stifle culture. And I think, there's a very interesting book by Gregory Smith, another lawyer, called Paper Safe, that basically just says that bureaucracy in aviation is making it less about people, less about culture, and more about compliance with processes. And I'm finding that things that I used to see in my apprenticeship, like good husbandry when it comes to like engineering practices, locking wire, like cleaning things as you go, aren't happening, because we're taking things out of bands because they've got to be to a checklist that's just so sort of regimented that people are using scraps of locking wire and not cleaning things as they go, because we're another process or procedure has determined that we would have cleaner, sort of less things in vans, and it's just a constant kind of, it feels like it's a bit of a battle, if truth be told, and safety shouldn't be a battle. It shouldn't be like that. It should be a culture, and you should be able to say these things. But I totally agree with what the previous person said. I think didn't catch your name. Sorry.
Yeah, I'm Florin.
Yes.
Is it? Can I just ask? Is it too much process or the wrong process?
I think it's well-intended process, but it's going to have a knock-on effect. It's, for example, they'll find the wrong serial number ladder in a van or something, and that's a finding. And I'm not saying that that's not important, but what is more important to me is that people are using a fresh bit of locking wire that they've got of a reel, not a little bit they're finding in a bag, or in a pocket that's just been stashed away. Locking wire should be ready available. Rags for cleaning should be ready available. Cleaning products should be ready available. We teach these principles in EWIS, but what is the point in doing EWIS training and telling people to have a mentality where you clean as you go and teaching people about good practice when you effectively tie people's hands and don't permit them to have the tooling and the material available? Does that make any sense? That's one example, but I can give loads of others, but I don't want to go too much into detail for specifically my company. I don't want to make myself a whistleblower.
Yeah.
Sure. Hazel, do you remember when we were at the CAA, there was a program called Stop Doing, Reduce Doing, where we looked at activities that we considered redundant and had really been processes that had been replaced by newer things that we were doing.
I do, yeah.
It's a good exercise to engage in, I think, for every regulator, is to look at, are there any things that we should stop doing or reduce doing? What every organization that has an SMS is supposed to do is engage in a safety assurance review. Hazel and I are very familiar with safety assurance review. We conducted one at the Civil Aviation Authority, and you look at all your processes and procedures and make sure they're adequate. But at the same time, there should be within that context, looking at what's not needed anymore. If there's anything that you were relying on at one time, because the whole point of looking at doing a safety assurance review is what is it we're actually relying on to deliver safety? What are the unwanted outcomes we're trying to prevent? What are the procedures that we rely on? And doing a checklist, a health check is what we refer to it as in terms of our oversight obligations. It's a good exercise for any company with an SMS, they do it. But I guess that's where I would also say if there's something in there that doesn't need to be done, the only way to really address it, though, if your frontline staff, well, first of all, if your boss listens to you, that's great. If your boss doesn't listen to you, bring it up with one of the lawyers and say, I don't know if your lawyers in your company are trustworthy or not, but if you can find somebody you trust to say, there's actually some procedures that are getting in the way of me being able to address safety concerns, that is an issue. If there's anything you see, and this is Tenerife right here, anything that you see that's causing you concern about safety is something that should be brought up. Doesn't mean everybody's going to agree with you, but should be addressed, and you should not be punished.
Yeah,
no, but it needs to happen.
I'd like to get to the bottom
agree,
of
but
where is this pressure for the additional bureaucracy coming from? Is it coming from the regulator? Is it coming from your inspectors? Is it coming from your management trying over hard to comply? Where is this coming from?
Well, may I take this question? Yeah.
Please.
Well, in my particular case, I think it's coming sometimes from some sort of over-interpretation of the regulations and AMCs by the inspectors, the CA inspectors in our case. So I think if we would like to go to, let's say, the root or the basis of this, I think should be the regulator encouraging to basically have manuals and procedures just in the appropriate amount to do your job, not to copy paste every single paragraph or AMC guidance material and all these type of things. But I think this is rather a cultural issue because I have noticed that being quite differently approached by different CAs. We also have an UK CA 145 approval, and I saw the approach, it's different from the different CAs. So I would rather say it's a cultural issue. But in connection to that, I would like to ask Domenico, if I'm allowed, please. In case a CA is coming to audit an organization and will issue 50 level 2 findings, then in my opinion, it's definitely an organization breaking the law in 50 different ways. That's something wrong, obviously, in terms of safety. But I think in my perspective, should be the CA somehow taking part of this failure, because in the end of the day, you approve the accountable manager, the nominated person, the procedures, the people, you interview them, and all these type of things. But rather, I saw that the type of reaction say, well, you guys didn't do your work very well, and you are the one to be blamed about that. What's your point on that, Domenico?
Yeah, that's the whole idea of continuous monitoring, is that you're going to find out earlier on in the process when there's deficiencies, and that you shouldn't have so many level 2 findings on an audit, because these issues would have been discovered earlier on. I do think it does implicate that maybe the regulator and how they're implementing some of their obligations might not be, without picking on any regulators, but might not be appropriate. It might not be adequate. And I think that there probably should be some training. I do think a good regulator is going to look at that and say, wait, we just found all these different level 2 findings here. How come we didn't discover this sooner? Are these all new things that's because of a management change or because of an organizational change? Or what's at the root cause of all these level 2 findings? I think any good regulator is going to say that and actually have their inspectors sit around and say, what really happened here? Will any of them ever admit publicly, yeah, we didn't perform our oversight well, and they're never going to do that. It's just not going to happen. But at the same time, if I were working within an aviation authority and I saw that, that a team of my own inspectors came up with that, with all these findings, and say, these are the kinds of things that unless there was something major change within the organization that happened, this should have been discovered a long time before. And even if there wasn't if there was a major change, those are the kinds of things that during the accountable manager meetings should be addressed and should be looked at and say, all right, well, if there's going to be a restructuring of this division, what sort of testing have you done to make sure that these functions are going to be carried out? It certainly does. I do see your point where and especially if it's happening within several companies, that would be, I think, a big test for me if I were working in a regulator, is if it's happening within several companies that you're finding having a lot of audit findings, why aren't some of the problems being detected sooner? Why isn't action being taken to address them sooner? An ounce of prevention is much better than a pound of cure. So it's certainly a valid question, and I'm very happy that you bring that up. Will they ever admit, though, that, yeah, we should have discovered this earlier? No, they're going to put the blame entirely on the organization. That's just the culture I've seen in every regulator I work with.
I'm going to ask the question, though. What is actually wrong necessarily with an audit finding? Because to my mind, if you're inspecting a company and there is a finding, that's not, it depends what the finding is, obviously, but it's not necessarily a bad thing, because what can happen is you can say, this is exactly what's happened with, like, and it's a small example, it's a frontline example from the line, but like taking locking wire out of vans. The reason is that it didn't have a GRN on it, so there was no traceability for the locking wire. And as a consequence, it was decided that it was easier to take it out of the van. But now you've got the problem where people have got, like I say, like local bits that they've just stored and stashed somewhere. But you're never going to see that problem again at another audit. So you fix the problem from a bureaucratic perspective, but you're not actually seeing the real world safety implications of people using scraps of wire that they find lying about to do wire locking now. So as a consequence, actually, I don't necessarily think that the finding itself is a bad thing. If all that's happened is a label's come off a bit of locking wire, and that's a finding, but you might keep having that same finding again and again and again. But the drive for continuous improvement is actually the problem itself. Does that make any sense?
Florian, do you want to address this?
Well, I don't actually see, well, I see findings, and I'm trying to learn from every single audit, even as a accountable manager, because I see audits like a way of improving your operations. So I don't believe there are perfect organizations, and I believe there will never be perfect organizations. But it's the most important thing with safety, I believe, it is to learn from experience and try to improve and never repeat the same mistakes. So I don't see necessarily something bad within findings, but I see way of opportunities. But what actually I disagreed on the earlier topic was that you cannot, because that particular CA came with a public statement on their website and said it's fully the responsibility of the organization because we canceled the airworthiness certificate of their aircraft, and they canceled the flights, and passengers were remaining in airports and so on, and they are fully and the only ones responsible because we issued them 50 serious safety findings. Well, this is the point where I'm disagreeing. It's the approach to the problem, not the findings themselves, even though okay, I can say if you have 2-3 findings during an audit, that's something normal based on my experience. But having 50, then should be some question marks to be raised against that processes. So I don't know if that was your question, Tom, but I don't see issues with findings themselves.
Yeah, I mean, findings are kind of, they're not good. I'm not saying that finding, but then they're not a problem in themselves. Some things you've got to try and improve them, but I think sometimes by implementing a process to try and stop a finding, that can cause other problems that you're not going to see, if that makes any sense. So I don't think,
yeah.
I mean, I don't know what these 50 findings are, but from my point of view as a frontline worker, that company could potentially be safer than a company that's not got any findings, because they've pushed all the problems by getting rid of locking wire out the vans, for example. That could be one of the findings, having no label traceability. You've got exactly the same problem, but you'll never find it again, and you've actually made it worse, if that makes any sense, because people could be getting locking wire from their shed at home. So to my mind, the findings not necessarily isn't the problem. It's the kind of it's the process that follow on from the finding to try and get rid of the finding is the problem. And I think it's difficult. It is very difficult, but I think you can't fix everything with process and procedure.
That was my point on the first question to Domenico, that I saw that increasingly we try to patch things with more regulations and procedures, which actually in reality we have some cognitive limitations. And the most simple one is, because always people, did you follow the procedure while you were replacing the wheel on the aircraft? Well, our brain is not designed to read and do things at the same time. So basically, from cognitive point of view, that's impossible. So I see exactly the same you presented. We, as a consequence of findings, we put more and more procedures in place, which don't necessarily make the activity safer, but sometimes more bureaucratic.
Yeah, and then that was on the Nimrod review, the aircraft that crashed that I was sort of a part of. Charles Haddon Cave wrote like a long document that basically highlights all of these sort of problems, and I think the most kind of poignant thing to me to take home from that is just keep it simple. Don't overcomplicate stuff with procedure. But unfortunately, I find that the regulator just comes in and just doesn't understand safety and says, "Oh, we need to do this, we need to do that," and it bolt-on procedures come in, and actually, as a consequence, it totally decimates culture, and it totally introduces bad practice into the companies, and you don't see it because you'll never find it again, because you fixed it with procedure, but it's a paper fix, it's not a proper fix.
That's really interesting points, I think. And something that I've seen over the years is, for me, the heart of safety management is identifying what root problems are and fixing them. And everything around that was put there to help that actually work in a company. But there is a temptation to fixate on the details of the guidance, because if you're doing an audit, I guess it's a nice easy thing to to fixate on, rather than the fundamentals. Do we know what our issues are, and are we doing something about them? But I think what you've said about the locking wires, and that really rings home. That's not what you fix with another process being slapped on.
Yeah, what's wrong with plastic scrapers being in vans? That's another audit finding. I just think that they're disposable. If you've got a plastic scraper in a van, you're more likely to use it. If you haven't got a plastic scraper, you're more likely to use a screwdriver. And it's. I don't understand why they're findings. They shouldn't be findings, as far as I'm concerned.
So a bit of interpretation then is.
I'll tell you this, just with the legal background, there's always going to be a desire to document things. That's always going to be an issue, because it's one thing to know, but it's another thing to be able to prove. And that's where I think you get a lot of organizations wanting to, if we ever get called into question on this, how do we prove it? How is it that we're going to be able to show we fulfilled our obligations? Now, you may know you fulfilled your obligations. Your staff may know they fulfilled their obligations. Ultimately, this is where compliance does impose upon us the burden for how do we ensure as a third party, as a regulator, that you fulfill your obligations. How far does that extend deep into your operation it's the $64,000 question, I would say, is how scrutinous does a CAA have to be about minor details and about procedures and things like that? That's a $64,000 question. But then also, even for things that the CAA hasn't established rules for, but your company's established procedures for, okay, how much of that needs to be documented? Is that the kind of thing that's really going to come up as a legal issue ever? And I think that's where it might actually be a good idea to ask that question. Is this ever going to be a legal issue? Is this ever going to be something we have to document and we need to be able to prove we've done? If the answer is yes, and this is just me as a lawyer talking, if the answer is yes, we have to be able to prove we've done this, yeah, then you're going to have to document it somehow in order to have that proof. If not, then yeah, that might be a good argument for we're never going to have to be required to show we've done this. This is purely an internal issue. Perhaps we can rely on our staff to do it. But I will say that we do always take the more careful approach in terms of, if in doubt, document. If in doubt, make sure you have a record of something. And as I showed you before, that whole case with the earthquake, in terms of engineers being held liable for not being able to predict a catastrophic event, that's a reality in some places. So in some cases, rules are designed for that.
And I'm not saying that I'm not anti-process and procedure at all, because we have to be. I always follow the maintenance manual. But what I'm saying is that a process or a procedure that's been implemented that's ignored is more dangerous than anything. And you've only got to look at the there's a petrochemical accident in the States, in Texas, that basically they had permit to work scheme, and it was just totally kind of overlooked. It was just signed off. It was just it just become second nature. And the problem is I'm not a safety manager, I'm just a frontline worker, but you, as a safety manager, you have to be aware of what's going on in the company. But unfortunately, by fixating on the paper and not the people and actually what's happening on the front line, and the process you've got in place, and the fact that you can't report because you've kind of tied many people into the sort of the complicity of it, is actually more dangerous in the first instance. I think, as crazy as it sounds, like a duplicate inspection is like a gold standard. It's a really important thing on an airplane. And the more you turn around and say that a duplicate inspection needs to be done on things that aren't safety critical, the more likely you are to have people that will sign off things without actually checking them. And that's the most dangerous thing. That should never, ever happen, because you don't know it's going to happen as a quality manager. So you kind of, by introducing more and more procedures to check more and more things, it kind of damages the safety, and it has the opposite effect than intended. And I'm really passionate about this because it can save lives, And
Sure.
I think you've given us a great deal to think about, Tom and Florin. Something that we'll take offline and perhaps think about a little more, and how that can be addressed. Sadly, we're going to have to draw to a close because we're kind of coming on for 1:30, which is our closeout time. Big thank you to Dom for joining us and giving his time to IFA and to all of us on the call, and to the people who listen to it afterwards. Dom, any closing remarks?
No, I think first of all, I'm very honored to have been chosen by Hazel. Hazel and I, we work together on a lot of things. I just also want to thank all of you for the work you do every day. A lot of times you don't get thanked, you don't get appreciated. I want you to know that as somebody who works very deeply within the regulatory system, I appreciate what you do, and I appreciate the actions you take on behalf of safety. It's what we rely upon. It's very important for the traveling public, and it makes sure that we're meeting our legal obligations every day. We've got a lot to be proud of as an industry. We've got some, as we see, some issues that we're going to have to sort out in the future. It's discussions like this that I'm always happy to be part of that are the catalyst for how can we do better. So thanks for having me here today to be part of that discussion. Hope you learned a little bit about what rules and regulations and laws and the system, how it works and underpins what you do. And of course, if you have any follow-up questions, I'm always happy to engage in them.
Thank you, Dom. Thank you for your time and
Great.
your wisdom as always. And thank you guys for joining the call.
Thank you. Bye-bye.
Thank you.
Thank you so
Very
much.
much.
Thanks, Hazel. Much appreciated. Thank you. Take care.
Thank you.
Thank you, IFA. Thank you so much.